Yes, Miss Markham.
My lord, my lady, I open the Re-P third appeal.
Yes.
And you now have, with the addition of Miss Clements, King's Counsel, the lead advocates in the Re-P hearing.
Yes.
Along the front bench, and I think you are familiar with each of them.
Yes.
Next to me is, of course, the second appellant, who is Mr. Bagchi, King's Counsel, who represents the
Yes.
child. And then my learned friend, Miss McKenna,
Yes.
King's Counsel, represents the mother. And my learned friend, Miss Basley, King's Counsel, represents the other putative father. My lord, my lady, I know that you know the background to this case. And tomorrow we'll develop the welfare points. And many of the legal points do fit into some of the welfare arguments. So there may be bits that I'll address tomorrow, if I may, particularly given some of the framework of the common legal issues.
We are, of course, itching to get into the detail, but we floated yesterday
Yes.
the question of whether this realisation that some testing could be achieved for much less, still high price,
Yes.
altered matters. Have you had time to consider that?
There is developing information that has been coming through the Guardian's team. So Mr. Bagchi, King's Counsel, is going to update you in relation to that.
Right.
I have not yet had an opportunity to go through that
Well,
in
let's
detail
proceed
with
as
my
if
client.
we haven't got that information, and if it comes and it changes. And there may be a need, given that the testing was thought to cost £90,000 and now it's thought to cost 14. It may not be the same thing that's being proposed, but
Yes, and what we know is there are complexities around it that may or may not give the desired outcome.
yes.
But it's certainly...
We'll proceed as planned, and
Grateful.
then hear more if there is more to hear. Yeah.
Thank you. Well, I'm not going to, you'll be pleased to hear, trespass over a lot of the issues that my lord and my lady have already heard. In general, and absent any points to the contrary, we will align ourselves with the arguments for the Secretary of State in relation to parental responsibility, birth certificates, married and unmarried fathers, if I can put it in that way. The facts and the submissions on this case are different and exceptional, and possibly one of the only times that the court may have to determine these types of issues. May I ask you to start, please, just to look at the transcript of the judgment of Her Honour Judge Reardon, because that is what brings us here. And in relation to our ground one, which is the approach taken by the learned judge to the findings or non-findings that she made.
Yeah.
And in particular to page 240 of the bundle, which I hope brings you to paragraph 116 of the judgment.
Let's see. Yes.
So at 116 of the judgment, the learned judge found, and we say found, that the simple reality in this case is the court has not been able to make a finding as to paternity. And we say that that is the linchpin of the appeal that we bring before this court, because that is a finding that the court was unable to say which of the two possible people was the father of this little girl, and therefore there is no finding as to paternity. And if we then consider the submissions made on behalf of the Secretary of State about the need to have a coherent system in place for the establishment of paternity, we have part of that coherent system. It is a judicial consideration, and on the facts of this case, Her Honour was not able to say which of these two men was the father, and therefore we say she was wrong. We turn to 117 to have left F1 as a possible father on the birth certificate, because as we have heard, if a person cannot be identified as a genetic father, then he ought not to be on the birth certificate.
So what jurisdiction did the judge have to remove him from the birth certificate?
Well, my lord, what Her Honour says further on in the judgment is that she was not certain what the registrar would do were it to be provided with a finding of the court that it could not establish paternity. What we know now from paragraph 46 of the GRO's skeleton argument if it is told that such a finding was made, it uses the word declaration, but I'm going to say such a finding was made, it is likely to re-register the birth to remove the
That's
name of the father.
not the way I understood.
Well, I'm looking at paragraph 46 of the GROs.
46.
Yes, that's 391 in the bundle.
No. I've got that at 371.
Oh. 371 electronic page and
46, you said. So in
Yes,
respect to
391
proposed declaration
electronic.
4, so
yes,
proposed declaration 4, previous page, it is declared under section 55A that neither F1 nor F2 is the father. So in respect of declaration 4, the
Yes.
Registrar General says, clearly states neither of them is the father.
yes.
It's anticipated the Registrar General would authorise registration. But is it possible, does the court, if the court can't decide in the way that Judge Reardon couldn't, it's not possible to make a positive declaration that one or other is the father, but equally, it's not possible to declare that he's not the father. Isn't that the position?
Well, my lord, we say that the learned judge was wrong in two parts in relation to that. The first is that she did make a positive finding, because at 116 she says the court has not been able to make a finding as to paternity. That's the finding. The court couldn't say this person is the father.
The word "not" appears in it.
But the court did not make a finding that this man or that man was the father.
Yeah.
And that is the outcome of the case.
But the declaration 4 is that you declare that neither of them is the father, but we know one of them is. So how can you declare that neither of them is the father?
Well, Lord, then that goes into the other issues that I'll develop as I come through about the problem for the
danger
other
of me
father.
derailing your submissions, but
No,
I'm interested. This is an appeal against the orders made by Judge Reardon, and so what order do you say the judge should have made and was in error in not making?
Well, we say that the learned judge was in error in relation to the expression of the findings.
Now, what order should she have made?
She should have made a declaration that she could not have determined that either of these people was the genetic father. That doesn't mean that either of them is the genetic father, but she could not determine which one was the genetic father.
Should have declared that.
Repeat that, would you again?
Yes.
So I could write it down.
Declared that the court could not identify which of the two was the genetic father.
Right.
That we say that doesn't undermine the question that one of them might be, but the court couldn't determine which one is.
And again, I'm in order to
Yes.
help understand where the issue is that a declaration that can be made under section 55A? A declaration that we can't decide?
Well, my lord, we're saying that in the unusual circumstance of this case, it is a declaration that can and should have been made,
Yes.
whether or not within this framework of section 55 or outside of it.
Or it may be under the inherent jurisdiction.
Yes.
But that would, I would have thought, summarise Judge Reardon's factual conclusion, because she couldn't decide couldn't identify which of the two is the genetic father.
Yes.
But part of her finding is also that one or other of them is. The pool of possible genetic fathers is these two individuals.
Yes, and that may often be the case. In this case, though, it's the complicating feature of there are two closely related and closely aligned possible fathers, and there often are cases, which is the whole purpose of declaration of parentage, where one person has been identified as a possible father and then somebody else appears and says, no, I think I am. That's not an unusual situation for the courts. The unusual situation in this case is the close genetic link between the two possible fathers.
Thank you.
And of course, one needs to read the judgment in its totality. because it doesn't just sit with 116, which we say if it had just been left with 116, and the outcome may have been easier to unpick. But of course, we say that in considering the invitation made on behalf of the child, J, by the guardian at paragraph 117, where the learned judge accepts and appreciates that the outcome would leave the birth certificate unchanged, it would on one view perpetuate an untruth, or at least a partial truth. And then the learned judge goes on to consider other aspects. A, that A may in fact be F1's child, so therefore the registration was not necessarily wrong, but of course it could also be wrong. B, the registration was a result of a joint decision by M and F1 in the belief that F1's case that he was the father. Well, because of all of the discussions that that the court has heard already this morning, in some ways, so what? It doesn't impact, because many people make a decision at a time believing a fact to be correct, and then something else changes that. Some people aren't honest about it. So we say that that doesn't assist the court in unpicking what to do for the certainty for this child. And certainly at C, we say that the learned judge went wrong when considering the impact and consequence of the decision that F1's continued presence on A's birth certificate may go some way to offset the harm I found likely to be caused by M's attempts to eliminate F1's role in A's history. Well, we say that doesn't have a place within a consideration determinant of parentage. But equally, if we're wrong about that, and those types of considerations are relevant, then that takes us to one of our other grounds, which is the extent to which the court ought to have regard to psychological parentage when you're looking at determining which of two possible people may be the legal or the parent of a child.
From the child's point of view, this is any child, I would assume, the truth is what most benefits them, and the truth here is complicated, and the truth is that on the present evidence, it's not possible to say which of these two men is the father, and that's the truth that this young person's, once they are told it, have to grow up understanding as best they can, and so that's that. The birth certificate is a complicating factor, but the important thing is for the child to have the truth in some way, and Judge Reardon has delivered that in her judgment. But your difficulty from your client's point of view is that the birth certificate is favouring the one over the other, and there's a danger, if not the reality, that it's being used in some way to establish a priority for one over the other. But the difficulty that I think I have is that the birth certificate's not in the direct control of the court. The court can't order. So we're trying to influence the Registrar General with the declaration, because your case is it's unhelpful that the birth certificate records something that in fact can't be evidenced.
Well, we're not trying to suggest that the Registrar General should be influenced. We're saying the Registrar General should be given the facts arising from the decisions in this case. And if we follow the submissions of the Secretary of State and the Registrar General, that the registration of birth should, so far as possible, identify the genetic truth of the child's parentage, who is the genetic mother, who is the genetic father, or the gestational mother and the genetic father, then in this case, the Registrar General hasn't been given the full details. And we don't know, the Registrar General may or may not exercise his discretion to amend the birth certificate, to put a note in the margin, to say this could be one of two parents, or to re-register. That would be a decision for the Registrar General. We accept that.
But isn't the Registrar General constrained by the statute and its own rules about whether or not it could put just a sort of extra note in the margin?
It is, and I wasn't, by my shorthand in relation to referencing that, I accept the statutory scheme set out by the Secretary of State. and the
Can't do
Registrar
what
General.
you're suggesting.
Well, it could do if there are declarations made.
Well, can I just go back?
Yes.
What my Lord
I can see my
President
lady
said
was
about
looking in the
it.
red book.
Well, all I was looking for was I was just looking up the wording of 55A, and then I decided I'd just look in the bundle instead.
Yes,
So you haven't actually taken us to 55A
no, I
yet,
haven't yet.
but it's very clear, subject to the following provisions, any person may apply to the High Court for a declaration as to whether or not a person named in the application is or was the parent of another person so named.
Yes,
And at 116 that you've taken us to,
yes,
the judge said, I can't make a finding as to paternity. All applications made or deemed under section 55A are therefore refused. Now, what, on a statutory interpretation basis, what is wrong with that?
well, we say the London judge was wrong because of her approach to the facts in this case. And I'm going to develop that further when we look at.
Sorry, I do want to be clear
No,
about
absolutely,
this so
ma'am.
that I can anchor
Yes.
all your
Yes,
rest of your submissions to the jurisdiction. The judge clearly, it's common ground anyway, that the DNA, as it stands at the present, the judge was unable to say which of these two
on a
men.
scientific basis, yes.
Well, I mean, unless you're going to take us back to the old affiliation
Well,
that we all did in the magistrates' court 50 years ago, I don't see what other basis we're going to be.
Well, she had, and the judge heard oral evidence, didn't
Yes.
she? She did that exercise,
she did.
and she said, "I can't tell."
Yes, and we do say she did go back on the old affiliation case, which is why we've cited the Anderson case. And because if you can't use science to assist you, then you do fall back on the facts. But what the judge,
You're saying you're seeking challenge findings of fact then? Are you saying the judge should have found as a fact?
no, well,
I didn't think
I have to be careful because my grounds for appeal don't say that. But what I am saying is the way in which she came to that decision was wrong because she didn't look at part of the psychological aspect of my client's role as a father, and that is one of our grounds.
So
And that is
you are saying she should have found as a fact your lay client was the father, and therefore she could have made a declaration under 55A that the other father was not the father,
well,
and could have then he registered.
if, as the learned judge said she did, one of the purposes of keeping, for example, and maintaining father one's name on the birth certificate was to do with welfare matters, as she did as a 117C, she's looking at that psychological aspect and relationships. We say she ought also to have looked at those in relation to our client.
They're different parts, they're different stages of the judge's analysis. She's really back calculating, saying, well, it's not the end of the world if he remains on the birth certificate because of these positive factors. You're now saying that that was relevant to the finding about which of the two was the father. Well, that's a wholly different aspect of the case. I didn't understand you were appealing the fact finding at all.
Well, in arguing that there was the
I
psychological
thought
parent
you
aspect.
opened your oral submissions by taking us to paragraph 116
Yes,
and said this is the root of the case.
it is, but my lord, you took me off different paths, and I was going to come to that in any event to say if you're not with me on that, I was
Sorry.
coming on to that. What it seems to have done is looked at it as if this was the root of my case, and it's
Sorry,
not. That
that's
was
my
a side
fault.
issue. I was going not a side issue, it's an
But
important
Ms.
issue.
Markham, I think you're because of the judge's judgment and then the way the appeal's constructed, you're tied to the judge's decision that she
Yeah.
can't tell which of the two is the father. 50-50.
Yeah, and the psychological part of it was also part of the appeal in relation to the failure to make orders in relation to parental responsibility.
But given that the Secretary of State and the respondents in the other appeals cases that the psychological elements are not relevant, it's the biological parentage full stop which determines who the father is. The psychological elements wouldn't have assisted her anyway, would they?
Well, they would if you can't determine on the scientific facts, because you do then fall back on Anderson and affiliation type cases. But I accept and recognise what you've both already said to me, which is that is a finding of fact. And our grounds of appeal haven't
Right,
looked
okay,
at
well,
setting those
Proceed on that
aside.
basis.
I think I'm getting thoroughly confused. forgive me if I am. You've spent a day and a half looking at section 4.
Yes,
The application, on your case and Secretary of State's case, the application, section 4 applies if the putative father is genetic father.
yes,
That has to be shown on the balance of probabilities.
yes,
So neither F1 or F2 can satisfy that test.
yes,
Section 55, again, the application is based upon an assertion that you're the genetic father. If you can't prove that on the balance of probabilities, an application under section 55 is bound to fail. You then, as I understand it, have various alternative routes which we can look at in turn, but which to a greater or lesser extent depend upon whether you can show that he's either a genetic father or a psychological father. But have I'm getting confused in the argument about what should have been said by the judge. It's perfectly acceptable in real terms. I mean, it's deeply unsatisfactory in other terms, but it's just a consequence of how this child came into existence. It's perfectly acceptable for a court to say the balance is evenly spread and we can't find one way or the other on the balance of probabilities. Doesn't that mean that section 4.1 doesn't apply, can't be satisfied?
absolutely,
Section 55 can't be satisfied.
yes.
And then where do we go from there?
Well, and going back to the section 4.1 not being satisfied, we say that is something the learned judge did not consider and did not look at by leaving parental responsibility with F1.
But if you and the Secretary of State are right
Yes,
about how section 4 works,
yes,
the solution is, or the conclusion is, or the consequence is inevitable.
absolutely. And I don't seek to argue against that. The learned judge didn't deal with that. And at paragraph 117, we say is where she went wrong in not dealing with that. So even if I can't persuade the court or the Registrar General, doesn't look again at the registration, whether or not F1 should have parental responsibility, we say is clearly dealt with through section 4.
It doesn't.
And he shouldn't have it because he can't be shown to be the genetic parent.
And
Yes,
then, as I understand it, and I may not understand it very well, it's up to the registrar and not this court to decide what, if anything, is done about the birth certificate.
indeed.
And at the very least, the sensible, also pragmatic solution, if the registrar is not going to change who the current state of the certificate, it should be annotated that
Yes.
in fact there is no finding that he's the genetic father.
My lord, yes,
That's it, isn't it?
yes,
Well, that's a better way of putting it, with respect, because to say that the court couldn't identify which of the two was the genetic father leaves the registrar without a positive
yes,
indication. To say that it's not been possible to prove that F1 is the father, that might give the registrar general a platform to say, well, we can't be satisfied he's the father, so he shouldn't be on the
yes.
birth certificate. To make a finding that he is not the father is not possible on the
Can't
evidence.
make a finding he's not the father.
But you can say that it's not proved that he is.
Yes, I mean, it is,
If some hapless registrar sitting in an office on a wet Tuesday afternoon is presented with all of the evidence we've got here, and the couple, the mother and F1, go in and say, look, cards on the table, it's only 50% that I'm the father, I can't prove on balance problem I'm the father, the registrar
good mum.
might say, well, I can't put you on the certificate.
That's what he should say.
And that is entirely the point I was making in a very clumsy way, perhaps because I got distracted.
I think you
after the
weren't
declaration.
clear. You were very clear, but I think it's where you which
It's the route to
way
which.
round you
Yes.
go, and to say that we can't prove he is likely to be more effective
Yes.
than saying we can't say which of them is.
Which is entirely what the learned judge did do when she made the finding that she's not been able to make a finding as to paternity. That was the point I started with. She hasn't been able to find that A or B is the father. And having made that finding, it does impact on whether or not F1 has or ought to have parental responsibility.
Yeah.
And that's when I then took you to section 117 of the judgment, where the judge tries to deal with why he might still have parental responsibility. That might be a good thing or a helpful thing within the welfare aspects of this case, which likely to develop more tomorrow, because that does deal with some of the other welfare matters in this case. But we say actually in a simplistic way, there is no finding arising from this judgment as to who the father of this little girl is.
There is no finding that either of them is
Is the father, yes.
There is a finding about one of all that can be said is one of them is.
What,
Cannot,
yes.
but that's not good enough.
No, it's not good enough. It's the factual determination that there is sufficient evidence to point to one of them and say this is the father. That there isn't that in this case.
Right, we've interrupted
Well, it's probably taken us through
persistently
it
for half an
quite-
hour, so
Yes.
we'll let you get on.
I probably don't need to deal with some of the other matters if that route through is understood and accepted as being the way in which we put the case on behalf of our client. And because at the heart of this case, as you know, his concern is there's this difficult situation, and he is left in quite a different situation to that of this person that's in exactly the same situation. And one has parental responsibility and one doesn't. And he is seen to be, so far as the child is concerned, her father and her psychological parent. So regularising it will assist the family, we say, moving forward. I don't think I need to deal with my submissions in relation to the imbalance that's created, the illusory aspect of one person's name remaining on the birth certificate, because I think we have had that sufficiently from other submissions this morning. I'm trying to cut through so I don't take up the time that's not going to be helpful. Most of the submissions that I would wish to make in relation to where we say the judge was wrong not to make an order in relation to my client for parental responsibility is linked through to the welfare aspects. So I don't know if my lords, my lady want me to deal with that more tomorrow.
I think that you ought to deal with them now. I think it's not going to be, given the rather piecemeal way we've been proceeding, it's better to keep things together.
Certainly. Well, again, turning to the judgment, we look at paragraph 130, which is at, I cannot see the numbers of it because it's been so overlaid, I apologise. It's at 242 of the electronic bundle and 241.
Yes, it's all been overlaid.
It has, I'm sorry, I can't read it.
Which paragraph was it?
It's 130, it starts at the bottom
Yeah.
of page 18. And of course, one of the difficulties that Her Honour faced at the time, as she expresses there, F1 has parental responsibility for B. Whether or not he has it for A depends on the answer to the question of whether a man who is equally likely to be and not to be the father, and who is named on the birth certificate, has parental responsibility for the child. Well, I think we've just addressed that, and whether or not the learned judge was awaiting the Court of Appeal decision, because she says it's a question which adds an additional layer of complexity to the issue which the Court of Appeal is due to determine later this year. Well, we say it.
But the judge didn't need to do that. She could have said, well, here we are now. What's the position for the future? Should this man have parental responsibility in the future for this child, and make a freestanding order under section 8 in whatever configuration? And if she decided it was in the best interest for PR, then grant PR.
Well, absolutely.
That would have cut through the whole thing.
It would have done, but she didn't do it.
No.
And we say she was wrong.
absolutely. But 2020
To cut through it all, my lord, absolutely. And she got herself tied up a little bit, worrying about that question, and it distracted her from looking at what was needed for this little girl, and also the difficulty that we say that if she had got herself in the difficult mindset of saying, well, neither parent is a father or is the father, did that distract her from considering a non-parent under section 12 and whether parental responsibility could be given in that way? And we say it did. And it's the Schroders of cat point that having got herself caught in that problem, she didn't then properly consider, either through a welfare framework, looking at psychological parenting, looking at what would assist the scaffolding for this family. She just didn't do it.
Yeah.
And I think
And she should have. I think the other side of the coin that I was referring to a short time ago is that if she decided you should have PR, she could make a fresh order.
Yes.
If she decided he shouldn't, she could terminate his PR on the basis that if he's got it, I'm going to terminate it under section 2A.
Yes.
So subsection 2A.
But she didn't because of three different issues. I think one is that the learned judge was concerned that this issue might be being dealt with in the Court of Appeal. Secondly, that she had left herself in this tricky situation of both parents being parents and non-parents, and therefore did section 12 apply? And she didn't. You can see when you read through the judgment, she didn't ask herself, therefore, those questions. But what it did is it left both fathers, arguably, and this little girl in a situation where, particularly my client, a man who is, to all intents and purposes, the father of this little girl, without any parental responsibility, and all the obligations, rights and duties that brings with it.
But you can't say he's the father to all intents and purposes.
Psychologically, to all
That's
intents
the point,
and purposes. Yeah. I can't say to all intents and purposes because he's not been proved genetically to be so, but psychologically, for this little girl, she thinks he is. Whether that's right or wrong is not the point, we would say, for the moment, particularly in a situation where he is one of two possible people who could be.
Yeah.
And one can see through the judgment that the learned judge just didn't consider those particular principles and points, and we say she was wrong to do so.
You say that the section 4.1 point
Yes.
for a moment, you say in any event the judge fell in error because she should have looked at other routes of granting your lay client parental responsibility.
Yes.
So presumably on that basis your submission is that the appeal should be allowed in any event
Exactly.
and be remitted for, you would say, proper welfare consideration under the other appropriate sections as to whether your lay client should have parental responsibility.
Entirely, my lady. Yes. Just going to turn my back for a minute. Yes. And my learned junior reminds me, I think I made this point earlier, that section 12 can only be used if there's a finding he is not a parent. But of course, if the finding is that the court has been unable to find either one of them is the parent, then of course they can't be seen to be a parent. So section 12 would then apply.
Would be
And
possible.
there needs to be that clarity.
Yeah, but it's possible, isn't it? Sorry.
Sorry, no.
Under section 12, in the unusual circumstances of this case, to say it's not possible to say whether he is or isn't a parent. So either under this subsection or that subsection,
Yes.
but anyway, I grant parental responsibility.
Yes.
I think after my Lord Justice Stuart-Smith's analysis, you may want to rephrase the wording of your proposed declaration.
Yes, I will rephrase that wording. Thank you. And you can see where that particular point was considered by the learned judge at 129, but she didn't then go on to deal with it. But I think I was my lady have that point. Thank you.
Yeah.
On these issues, of course, there are more to be considered in relation to the welfare issues. Those are the main submissions in relation to.
But what else is there to deal with on the welfare issue? If you're saying the judge completely failed to
And it should be remitted.
It should be remitted. I'm sure what
Well,
else
it's the child arrangements orders, but they can be reviewed again, my lady.
we wouldn't be in I'm sorry, that's for you, my lord. I don't think we'd be making child arrangements orders. Is my lord
I
made?
don't think our lips move.
I'd feel a bit nervous.
Well, I'm not going to try and persuade you away from that if the view is that...
Persuade my lord.
Yeah.
If we're only hearing your submissions first, so we're just following that line. If it is remitted, there's no problem with going back to Judge Reardon. It's not a case where a judge has fallen into very substantial error and has predetermined matters and now would be asked to look at it all again, and that would be difficult. Or you think it should go to a different judge?
Well, there are...
Your gown's being tugged, metaphorically.
I know it is. There are elements within the judgment where we would say that Her Honour has formed a view in relation to attitudes towards parenting and managing of the parenting situation and relationships. For example, a paragraph 117C that I've already taken you to,
Yeah.
that we say may have infected and added the approach taken to whether or not my client should have parental responsibility or father one should
Well, she
not
may,
have it.
but she's been exposed to the evidence in this case. She may be moving towards a view one way or the other, but and we'll see. We'll see when we get.
My lord, that there are, as with every case, ongoing issues on the ground that may require any review in any event. So,
Yeah.
We will discuss whether or not there are any other matters that we need to take the court's time with tomorrow on welfare in light of that indication.
Thank you, Miss Markham.
Thank you.
Yes, Mr. Banks.
So, my lord, I might just need to rearrange the furniture a bit. I just
Do you
don't
want to
know
take
whether-
this?
Right, just
I'm actually going to deploy the box. That's appropriate. There we are.
so you're for the Guardian.
I'm for the Guardian, and we made an application at the conclusion of the evidence that there should be not declarations of parentage, but declarations of non-parentage. And the power of the court to make those declarations derives expressly from the terms of section 55A1. Because, again, for formality, 224 of the authorities bundle, the term used is whether or not a person named in the application is or was the parent of another
But it
person.
is well established that section 55 can be used for non-parentage.
Yes.
Yeah.
And our submission is that as a product of the findings made at the earlier hearing, which was a combination of the scientific evidence and the findings of fact, that it was impossible for either of the candidates for parentage to discharge the burden of proof to the tune of 51%, because the probabilities were fixed exquisitely at 50%. And so what we got into at that stage was a rather difficult and confusing debate about the power of the court to make a declaration of non-parentage in circumstances where it couldn't be asserted positively to the tune of 51% that candidate A or candidate B was not the parent, because they might be. On the exquisite facts of on the unique facts of that case. And it's fair to say that in terms of reasoning, we, on the behalf of the Guardian, we went round in circles for a couple of days, trying to square the circle as to what the court should do. And I think it's fair to say that at the time when I framed the original grounds of appeal, we were still going round in circles, because instinctively it felt that the outcome was wrong, but the formal legal rationale that would justify that approach was simply not apparent to us. And I think it's fair to say that the scales fell from our eyes when we read the written submission of the skeleton argument prepared on behalf of the mother, my learned friend Miss McKenna, when she put forward, she and her team, it's fair to say, put forward an analysis of the appropriate legal reasoning which should apply in circumstances where the court was faced with this unique situation, in the context of not just section 55A1, but also section 58, and the reasoning propounded by Lord Justice Peter Jackson in the P, Q and F case, because there was a moment in that case where he had to address directly the implications of a party having to discharge a burden of proof in relation to the application for a declaration of non-parentage. So if I may, just to set the scene, just to go through in a slightly formal way those provisions. So 55A we've had a look at. 58(1) follows on from that, a few pages further on, 230. This is where an application to a court for a declaration under this part, the truth of the proposition to be declared is proved to the satisfaction of the court shall make that declaration unless to do so would be manifestly contrary to public policy. So public policy consideration didn't apply in this case. The learned judge considered public policy and an earlier part of her judgment and discounted that it would have an impact on the formulation of her decision in that case. No one's appealed that finding, so I put that to one side immediately. So the truth of the proposition, and this is where we got confused, because ultimately the truth of the proposition really comes to the question as to whether or not the declaration should be made. But the question as to whether or not the declaration should be made is not the starting point. As has been so clearly articulated to you over the last day and a half, the starting point is the common law position. This statute is not providing the answer as to who is the parent. This statute, the Family Law Act, 1986, is facilitating a recognition of an underlying state of affairs. And the underlying state of affairs is who is the father, who is the parent. And so to frame the question in a rather circular way, which rather, instead of, well, can you prove that I'm not the parent, or can you prove that I am the parent, on this case gets you nowhere, because you end up going around in circles and ending up, with respect to the learned judge, in the situation in which she landed, which is, well, I'm simply unable to make a decision on the application before the court, which is an application under section 55(1)(a). But the correct analysis is to stand back and assess the common law position, because has either of the candidates been able to discharge the burden of proof in relation to establish that they are the genetic parent of this child? And it's not just the genetic connection in this case. We have to go further than that. As my learned friend says in I spell it tonight, it's the progenitor of the sperm. It's the person who supplied the sperm. That's the granular analysis of proof on the facts of this case. Because of course, the genetic analysis produces two equivalent results, and we're looking for one result. So could either of them prove?
When you say that, are you talking about section 55A?
Section 55A and section 58(1).
So section 55A, the starting point is what declaration is being asked for. And as I understand it, that what was being asked for was a declaration in relation to either F1 or F2, I can't remember.
Both of them. I was asking for an...
But in which case, isn't it open and right for the court to say, because the truth of the declaration is not of either declaration, but you can deal with them compositely. You could say, I'm not prepared to make a declaration either that F1 is or is not a parent. I'm not prepared to make a declaration that F2 is or is not the parent. Reasons equal probability. Well, and then you have done the truth. You may have put it in your reasons, and you can find other ways of expressing it. But that's what they have to do in these circumstances.
What is the pure legal analysis of the situation in which the learned judge found herself in? I asked rhetorically.
The pure legal analysis is that she cannot properly make the declaration that is sought of her, which is that F1 is the legal parent, or the genetic parent, however you describe it. She can't make that. She can't make the declaration in relation to 2. She can't make a declaration whether or not, because it's on the cusp.
But I would submit that as a matter of law, if the clock is stopped at that point in time, then neither of them can establish the common law position in relation to parentage. And that analysis precedes the analysis as to whether or not the declaration should be made.
Yeah.
Because we track back to the common law.
It is the reason why the declaration that was sought cannot be made.
Yeah.
One way or the other.
Well,
whether or not.
Our approach to this problem at the time was to formulate a rather elaborate sequence of declarations. I don't know whether my lord's seen those.
I think we've got, but certainly they've replicated paragraph 44 of, I think, Miss Markham's, no, the Registrar
Yes,
General.
I think it's paragraph 31 of mine.
44 of the Registrar General I've got. So one
So-
is biological father is either 2 or 1.
Yes.
Neither 2 or 1 have established to the requisite legal standard that either of them individually is or isn't the father.
Yes.
3, accordingly, as between 3 and 2 and 1, the parentage of A is not established. And then 4, it's declared under section 55A that neither is the father.
Yes. And I think
That's wrong. Linguistically, 4 is wrong.
that rather depends as to whether or not the court puts as its prime consideration the true common law position, which is that neither is positively establish that they are the father.
That's different from 4. That's not what's said in 4.
No, but the legal effect of that.
Sorry to wade into this, but 1, 2 and 3 are the reasons why the court cannot make a declaration as to whether or not the person named in the application is the parent of another person. Because no one can satisfy the burden of proof in any direction. So 1, 2 and 3 explain that perfectly.
But
But 4 it says that neither of them is the father, but we know
That's
one
right.
is.
That's right. One of them is.
but neither of them individually can establish to the requisite legal
Neither can
standard
prove.
that they
Neither can
are.
prove that he's
Yes.
the father.
But that's different.
But
But that's been covered by 1 to 3.
so I find myself being drawn back into the East London
Certainly.
Tower.
Yes.
Because this is the process we went through over many days. But ultimately, if the court drills down as to the legal effect of that finding and of that position, is that neither can positively assert that they are, and that must, because it's a binary problem, and therefore they must not be, and
So-
therefore.
So, but the help that is circling round in a holding pattern. Let's come to land. Let's bring you down to the runway. You read Miss McKenna and her team's skeleton, and you then saw a clear way through. So, what is it that you now say should the judge's declaration should have been,
Paragraph 4, and that would have been with
as it is written here?
yes, because that is within the terms of section 55. A1 because in their nature they are declarations of non-parentage. It's saying to each of the candidates, you can't do it.
It's ambiguous. If you leave 4 as it is, it's ambiguous.
Well, we hadn't even thought of 4 until we came to reframe our skeleton argument because 1 to 3 was the position we put before the learned judge, because we rather thought that the conclusion arrived at in paragraph 3 opened the door to the court exercising its jurisdiction under section 55A, because in its nature and species, it was in effect a declaration of non-parentage. And so, because others had raised the point that the court didn't have the power to make declarations 1 to 3 within the confines of section 55A, as a belt and braces approach, because we thought it followed on logically from 1 to 3, that paragraph 4 was drawn to the court's attention to say, well, if you need us to say it, spell it out clearly, there we are, paragraph 4. And it's important and relevant that the jurisdiction of the court to make the declaration is considered, because of course the consequence of the declaration being made under the statute is that there would be an obligation to notify the registrar, and then the registrar would. We've cited a decision of Mr. Justice Mostyn, and it was a short remark at the end of a judgment where he effectively said that once the registrar is notified, I would expect the registrar to act upon this, and effectively hinting that the discretion of the registrar to refuse that type of judicial indication was quite limited. Maybe not entirely surprising.
Been an idiosyncratic expectation.
Yeah, maybe. But it would carry, plainly, it would carry a lot of weight. And so it was important to frame it under Section 55 because the alternative method would be to have the declaration not made under the statute because it wouldn't fulfil the conditions to be made under the statute, and then, in theory, to be made under some other power. And the only other power that comes to mind is, of course, the inherent jurisdiction, which is something that we didn't raise in the moment on the day because actually when we were making our submissions on this, nobody took issue with the fact that the 1 to 3 could not fall within the framework of Section 55A.
So from the child's point of view, what's the outcome that the guardian seeks to achieve? Truth. So the truth is, as currently understood, what the judge has said in her judgment. We just can't tell. There's then the birth certificate. What's the guardian's hope in relation to the birth certificate?
In prioritising the application under 55A, the guardian's intent was to trigger the referral to the registrar under Section 14A of the BDRA, 1953, and as we now know, the way that tracks through to an alteration of the certificate is the removal of the registered father as the father, which is why we prioritise the statutory route. The alternative route to registration, which is being very clearly articulated in the registrar's skeleton argument, is the less formal route of 29A of the same 1953 Act, which is a process which doesn't require a formal declaration, but it's effectively the court making a finding, perhaps a finding incidental to other issues during the litigation, but a finding nevertheless, which then can be attested to in the form of a statutory declaration and referred to the registrar, who can then make their own independent inquiries about it and rely on it for the purposes of an alteration to the certificate, which does not remove the name of the father from the box, but does reflect at the bottom of the page in the margin. I always thought the margins were at the side, but you can have a margin at the bottom of the footnote. But at the bottom, you can, and there is, if we have just have a look actually.
So I'm looking at Section 29A.
Yes.
That's on page 54.
Yes. So there are certain preconditions to that.
Which section applies is wrongly shown as the father, or
well, the key element is there needs to be a judicial finding.
What does it say there?
So, 29(6).
A6. Finding means no.
29(6).
Sorry, I thought you meant no.
So 29, in fact I did a list. So 29A1A is a person who's wrongly shown as the father. 29A2, a statutory declaration by at least one qualified informant, that's a parent, or simply a credible person, not necessarily a parent. Then 29A3, documentary evidence of the finding that the person is not the father, and the finding is defined as the finding made in incidental judicial proceedings. And then we come on to the mechanism of re-registration, and that's helpfully set out in the regulations, the statutory instrument, the Registration of Births and Deaths Regulations 1987, Regulation 58, page 487 of the authorities bundle, which is bundle 1. So the question arises, what can the registrar write in the margin?
You're looking at 58.
58(2) On being informed by the Registrar General that the error may be corrected on production of such a statutory declaration, the Superintendent Registrar or the Registrar concerned shall, on production to him of the statutory declaration, correct the error in the following manner. B. He shall write in the margin of the entry a note in the following form or such other form as the Registrar General may authorise in any particular case. And then there's some words quoted there in relation to that. And so there's no prohibition because the suggestion is the following form, but discretion is given for different or more elaborate recording of the terminology and language to be used to explain the position. So it occurred to us that if the alternative pathway of section 29A were deployed based upon a judicial finding, then the terms of declarations 1 to 3 at least, maybe not declaration 4, it's controversial, could be recorded at the bottom of the page, which is probably the best that can be achieved, because what we can't achieve by this pathway is a removal of F1 as the father from the box. But the explanatory note at the bottom would go some way as to a formal recognition of the truth, and the truth as found by the learned judge on the best evidence available to her at the time she was taking the decision. And that is the truth. And that's a formal recording of the position for the benefit of the child.
In what circumstances can you remove F1 from the box?
Only when you have a declaration under 55(1)A, which tracks through to the power of the registrar to remove under section 14A of the 1953 Act. That's the only way.
You don't remove, you re-register.
Or re-register.
You
Yes.
remove the underlying.
Why doesn't that work? If you've, never mind the exact terms of it, but if you've got a declaration which says F1 cannot prove that he is the father, if you went to the registrar with that initially, the registrar wouldn't put him in the box. So why can't he take it out?
Because re-registration is dependent upon there being a formal declaration of the section 55A, which is why we were so motivated to argue strongly that the terms of the declaration that we advocated for should fall within the four corners of the statute. Otherwise, we'd have to go down the alternative pathway. That was the problem. Which is why we got into such a circular bind in relation to the burden of proof issue, and whether or not it qualified as a declaration under 55A1, the declarations, the dual declarations of non-parenting.
I'm keen to find a way through this, but I just wonder whether there's an impediment even under your section 29A route, and so that's back on page 54 of the bundle, because you took us to subsection 1, where it shows that someone is the father, 2, where a statutory declaration required by subsection 3 is made, blah, blah. 3, the statutory declaration must be accompanied by documentary evidence of a finding that the person shown was, as the father, was not the father. So that's the same problem, isn't it? That's the finding you just can't make.
But again, it's a bit circular, because it rather depends on the effect of the 50-50 finding.
No,
because if the effect of the 50-50 finding
unfortunately, the way it's worded is a finding that he is not the father.
Well, I would submit that as a matter of law, neither of them are the father individually.
Yeah, but that's different from a finding that they're not the father. I've got enormous sympathy for everybody in this, and I'm not trying to raise problems for the sake of it, but I think that's the Parliament, unless they had the time of an archangel on retreat, would never have thought of the circumstances of this case ever coming up.
But my answer to this, all of this problem, is let's look to the common law. If neither of them can displace the common law burden of demonstrating that they are the father, That's the gateway. That's the starting point. That's the baseline, which is the term used by Lord Justice Peter Jackson in PQ and F. That's the real starting position. And absent any evidence which shifts it one way or the other, then the natural legal consequences of that is that neither are legally the father, and that ought to be formally recorded in the documents of identity. Because there are very strong, as articulated in all the cases, public policy considerations which mandate very clearly that, first of all, if you can make a declaration, you should, unless there are public policy.
Must,
And that the vital importance of the child's identity in having the truth declared formally and in a way which is theoretically available to them as they grow up. And there are a host of cases that we've cited in relation to that. My Lord well knows them, because it's all Sir James Mumby, a decision of Mr. Justice MacDonald, in PQ and F. It's all there. This is the policy underpinning of why we try so hard to achieve certainty and clarity, because the child really benefits from that. Because I think it was the former president, Sir James Mumby, said that there's no more fundamental question than, is this my father, comma, is this my child? So for all of those reasons, we were striving hard to get as much certainty out of the statute and out of the legal situation which everybody found themselves in as possible. And in circumstances where neither F1 nor F2 could establish that they were the father, for F1 to remain with parental responsibility,
I can see that,
purely by reason of the fact that he was the one that went to the registry office on the vital day.
But did you accept that, as I put to Ms. Markham, the judge could have controlled whether F1 or, for that matter, F2 continued to have, or for F2's case, to gain parental responsibility by making different orders under the Children Act?
She could. Yes, two things. She sought to attenuate the exercise of parental responsibility by making the restrictive orders that she did do, and she could have conferred parental responsibility by making on the person who didn't have it by making relevant orders under the Children Act. Yes, that would have been possible. We submit that wasn't the optimal outcome. Because of the public policy mandate, if you can declare, do declare.
There's two related, but there's two separate things. One is establishing the truth for the child, and we've been there. The other is who, going forward, is having parental responsibility for the child.
Well, you will see that we have not challenged the welfare outcome in relation to that. The Guardian accepts that the judges, given the findings that she'd made, the judge's way forward in relation to the welfare outcome was unimpeachable and does not meet the standard to warrant interference. That was our position. So I think I've made the point. The reason that we were so exercised was because of the strong public policy consideration which underpinned the whole framework of this legislation and the imperative to do that. So if the court is questioning as to whether this court's power to make a declaration, my position is, one, under the statute as articulated. If not, what's wrong with the inherent jurisdiction? And that's the question that we've raised. So why couldn't the court, we ask rhetorically, make declarations 1 to 3 under the inherent jurisdiction, which could then amount to a finding that at least that would give a party the opportunity of deploying, we say, Section 29A, if the court is with me, that those findings could amount to a finding that neither of them are the father. But it's the same argument, really, because it's the same argument which engages Section 55A. So, I'm just going to turn my back. I don't think I've got much more to say about that. I'm sure the court's already glanced at these. these, but at the end of the registrar's helpful skeleton, there are some examples
Yes.
of registration, and I just don't know whether it's worth just having a look at those. So,
Am I? Because I'm afraid I didn't
three,
look at.
It's 394 electronically.
Thank you very much.
Yeah, thank you.
374 hard, 394 electronic. Yes.
And there's a very helpful index at the preceding page, internal page 17, 373 of the bundle,
Yeah.
393 of the,
4 examples.
yeah, 4 examples.
And these are, they've got names in, but they're not real cases.
No. My lord, they're made up, just to be very
Made
clear.
up, yes.
So, and example B at internal page 19 is the re-registration under section 29A, and we can see the entry there at the bottom of the page.
Yes, so the name, just so that those who haven't got the screen up, that the name of the person registered as the father remains on the birth certificate.
Yes.
But at the bottom it says the details recorded for father in spaces 4, 5 and 6 removed.
Yes.
So they're not removed,
They're not removed.
but they
They sort of are.
sort
Well,
of,
No, they're not. That's the
they're not removed. And there must have been a reason why in enacting the regulations in that way, that the decision was taken that the pathway under 29A would not open the door to an automatic power to remove the name from box 4.
whereas C is an old birth certificate that has been re-registered. And so the old birth certificate has on it,
Yes.
this certificate has been re-registered, and D is the re-registered
Yes.
version. Yeah.
So, my lord, C and D can only happen if we're in the section 14A territory.
Yes.
And so B is what happens even if you get in section 29 and 29A. If it's a correction of an error, this is how it is done. It doesn't remove.
Doesn't take the person's name out.
Yeah,
Yeah.
exactly.
That's very helpful.
Before I sit down, can I just draw the court's attention, because I will regret it if I don't, to P, Q and F, and it's the analysis of Lord Justice Peter Jackson at paragraph 39. So we have that in the bundle, I think it's bundle 4, 1453. Because that's the foundation of my primary submission as to the proper analysis of the questions arising. And it was particularly relevant in that case, because that's a case also with unusual facts. You'll recall, PQ&F was a situation of assisted reproduction in circumstances where a sperm donor was used, and in relation to a mother who was in a same-sex relationship with a partner. A pregnancy came about, and then it was revealed that at around the time when the artificial insemination was taking place, there was also natural conception, or the possibility of natural conception taking place, which gave rise to a factual question as to what it was, which process had given rise to the pregnancy. And on the facts, the learned judge at first instance was unable to say which method had formed the pregnancy. And that was relevant because an artificial insemination would have triggered all the consequences arising under this statute and effectively conferred parental responsibility upon the partner of the mother. But if it was a conception which had occurred through natural processes, that would have triggered the common law in relation to a declaration that the father was indeed the person who provided the sperm by way of process. And having found that each possibility was equally likely, the question arose as to what the correct analysis would be of whether or not the person who'd made the application for a declaration of non-parentage, which in that case it was the partner who'd made an application for a declaration of non-parentage against the father, as to whether or not she could displace the burden of proof. And that gave rise to arguments as to the sequence of questions, and which the learned judge in the Court of Appeal grappled with, I think, at paragraphs 38 and 39, 1453. Can I just read these out? Section 55A of the Act empowers the court to make one or more declarations as to whether or not the named person is or was the child's legal parent. In order to reach a conclusion, the court may have to decide issues both of fact and law, as it did in this case. 38, I'm so sorry. Its focus is on the relationships identified in the application, but it must reach its conclusion by normal process of fact-finding and legal analysis, leading conclusion that a named person is or is not the legal parent of the child. Section 58(1) of the Act provides that where it is satisfied the truth of the proposition to be declared, the court must make the declaration unless it will be manifestly contrary to public policy to do so. It is not directed to the truth of the underlying facts, but to the truth of the declaration, the legal proposition to be declared. It does not import a burden of factual proof into Section 55A, but mandates the consequences of the court reaching its conclusion about legal parentage, namely that it will make a declaration unless it will be manifestly contrary to public policy. That's the distinction which I sought to draw at the beginning of my submissions. And I think what we would say, just to emphasise, the truth of the underlying facts here is that is the common law position. The common law position is that neither can establish that either is the underlying word father. And that's the starting point. And paragraph 41, the judge was right to start from the position that a child's parentage will be defined by the common law unless it is displaced by the statutory provisions regulating parentage in cases of assisted reproduction. P is X's legal mother, X's genetic father will be her legal father unless that status is displaced by the presumption of legitimacy or by legislation. And so, by parity of analysis, we say that in another case where the possibilities are fixed equally at 50-50, the answer lies in a default back to the common law position. That's it. No. In our skeleton argument, we formulate an alternative construction to Section 55 based upon the floating of some Article 8 considerations in Section 3. I'm not going anywhere near that. I think I accept that that analysis would not bear the weight of the legal requirements in order to even begin to suggest that a wholly different construction be put on that statute on the facts of this case. So I'm not saying that. So it's either we're in the statute or we're the inherent jurisdiction. Thank you very much.
Thank you, Mr. Bagchi. Yes, Ms. McKenna.
My lord, I appear for the respondent mother in Re P, together with Miss Wiseman and Mr. Landon. The submissions of Mr. Bagchi identified the arguments that we sought to make in respect of the fundamental status of the common law, about which you heard lots this morning and yesterday, with which our position is clear. Finding the truth of the situation for the child in this case is obviously everyone's target. I'm not confident at the moment that I understand fully the position of the Registrar General and as to whether what responses there are that might be to the matters that are being raised. And I wonder if Ms. Clement wishes to take instructions or whether I should continue.
Well,
with
that
mine.
would be helpful because we've been proceeding in hope that one or more of Mr. Bagchi's suggestions hits the target.
My lord, we dealt in our skeleton with the 4 suggestions as were made in the written submissions. What was being discussed with my lord, Lord Justice Stuart-Smith was a potentially different declaration. I have tried to take instructions over email, but that is never satisfactory.
No.
I would like to take proper instructions
Yes.
as to what the registrar's position would be on that proposed formulation.
But let's I'm perfectly willing to give you time. We need to be clear what that proposal
My lord, that was then going to be my next request. Can I write it down word for word so that I can make sure I'm asking my client the right question?
Well, the later in the series of interventions, my lord suggested, I think, a declaration that the declaration would be that F1 cannot prove that he is the father. But earlier, that's the same. It can't prove that, it can't be proved that F1 is the father.
I'm just trying to find how I had written it down, my lord. I had written it down that there would be a declaration that there is no finding that either of F1 or F2 is the father. No, have I got that
No.
wrong? Very well. Can someone tell me what it was?
What I suggested was that existing 1 to 3 are in fact reasons rather than declaration.
Yes.
And that the declaration should be the court cannot say whether or not F1 or F2 is or is not the parent of the child.
Could that be two separate declarations? So the court cannot say
Yes.
whether F1 is or is not
Yes,
the
the
father.
court
Yeah.
declares that
Yeah.
A, it cannot say whether or not F1 is or is not the parent of the child. B, F2 is or is not the parent of the child. I have a sort of feeling that I'm wading in where angels fear to tread.
No, that's what you're here for.
My lord, the point is, it's the precise formulation of the declaration that will give the Registrar General a power or not give him a power to do
Yes.
anything. So I do need to take instructions on
And I
whether
would-
these
it-
declarations
On
would...
something as important as this, because clearly this is going to be on the record and reported, the Registrar General may not wish to be put under pressure with a phone call from outside the court saying,
Quite,
"I've got to
that
go
may be
back
the
in
response I get.
5 minutes." So I would be very sympathetic to that, but it would be helpful for you at least to open communications on that basis.
Could I have 15 minutes
Yes.
now? Or maybe 10 minutes, and if I can't get an answer, then I will put in a note after.
Yeah, so it's
afterwards.
now effectively 10:02 by my watch. So we come back at 5 past. So
I'm
everyone
grateful.
knows we've got 15 minutes.
I'm grateful, my lord. And if we
And
can't
how
get...
are we doing on time anyway? Depending on the answer,
Well, depending on the answer, very little or not very much.
right?
Sounds like a declaration.
And Miss Paisley, you're similarly.
Well,
I mean, you have more because you're
have-
for F2, F1.
I'm for F1,
Yeah.
and there are a number of
No, you
points
are.
on
No,
which
you-
we are the
no,
sole
absolutely
voice
right,
in
yeah.
respect of what
Yeah.
we submit. And so I would ask for my 30 minutes or possibly
No, absolutely.
40
No,
if
no one should
you
feel
allow me.
completely stuck on any time.
Thank you.
Yes. So we've got time, and if I'm keen that this ensemble of people aren't drawn back tomorrow. If we've only got half an hour to do, then we'll probably sit on tonight to do it. But if we've got more than that, then we'll come back. Good. Up we go. Sorry. Right.
My lord, thank you for the time. That was very helpful. I just wanted to clarify with my clients what the position would be. My lord, we've set out at 44 and 44 through to 46 of our skeleton argument
Yes.
what the Registrar General's position was likely to be on the then proposed declarations. If I can explain what the position is and then why in respect of these now proposed declarations. Under section 14A, so if this declaration was made under section 14A, the Registrar General's position would be that this would not be enough for him to exercise his powers under section 14A to re-register, because it is not a declaration of parentage in respect of that person. It's saying that someone is or is not the father of the child. So for section 14A purposes, once someone's name is entered on the birth register, we look at page 46 and the text of section 14A, what the registrar needs or what the Registrar General needs to receive in order to go about the re-registration is a notification of the making of a declaration of parentage in respect of that person, and it appears to him that the birth should be re-registered. So again, once the name is on the register, there needs to be a declaration either that the person whose name is entered on it is not the father, or it needs to be a declaration that another person is the father. So the declaration that the court cannot say that F1 is or is not the father is too uncertain for the Registrar General to exercise the powers under section 14A.
And similarly is, as my Lord Stuart-Smith said, is a declaration that he cannot prove to be the father. Does that fall into the same category?
Well, my lady, again, it depends on the precise words. If it's a declaration that he is not the father, that would be sufficient. But as I understand it, from the findings of fact made by the judge, that is not a declaration that the court could make.
It would be that it cannot be proved that he is the father.
Yes, which is not sufficient to take him off. Under the alternative route of section 29A, and correction in the margin, that is at page 54 of the bundle, and what is required there is that a person is wrongly shown as the father, and as my Lord the President pointed out in 29A3, the statutory declaration must be accompanied by documentary evidence of a finding that the person shown as the father was not the father. And again, my Lord, the declaration that your Lordship put to me does not say that. And indeed, it could not say that he was not the father because the court was not in a position to make that finding. So, my Lord, this is not a case of the Registrar General trying to be difficult. It is the fact that the Registrar General's powers to make changes to the birth certificate are regulated by statute. They are regulated by section 14A in the way that we've set out in our skeleton argument and are dependent upon the necessary declaration being made, or they are dependent upon his powers under section 29A and are dependent on the necessary conditions being satisfied.
Yeah.
So I hope that is not seen as being unhelpful. It is simply...
No, well, it's clarification, so it's helpful. The fact that it may not be the answer that some of the parties hope is another matter, but that's the position.
Yes. My Lord, I don't think there's anything else I can assist the court with on
No.
those points. You have our analysis of how the scheme works in our skeleton.
Yes, thank you. So we haven't discussed what I'm about to say, so this is a genuine question. Where does that leave the appeal, trying to catch Miss Markham's eye, and Mr. Bagchi? Because unless we're able to contemplate a declaration that the judge should have made, which does land positively with the Registrar General, the position is, as it was with the judge, that the birth certificate is as it is and is unlikely to be changed, and she had no power directly to change it.
Lord, if I lose on argument one and we're out with the terms of the statute,
Yeah.
and the court doesn't feel empowered to make a declaration of the inherent jurisdiction which would carry forward into a...
It doesn't matter. I don't think that we were necessarily thinking we were tied by section 55A there, because this declaration that we've contemplated is not a template one that you'd normally get under section 35A.
Yeah.
Yeah.
So if I'm unsuccessful on that, then given the need for the registrar to see a positive statement of one thing or the other,
Yes.
if the court can't deliver that,
Yes.
then I think we're stuck.
Yes.
Which is a really good reason not to construe the statute in such a way as to not leave the child in that position.
Yes.
And I track back to argument number one. That's why.
But the statute that we're construing is what? Is the definition of father, or the Family Law Act.
No, section 55.
Yes, so we haven't got there isn't a problem in construing section 55. It's a problem with the evidence, and the factual conclusion here is that it's not possible to formulate a declaration which is sufficiently positive or negative of parenting to enable the registrar to
Yes.
alter the
But
record.
I'm inviting court to interpose a further stage of analysis. It's not possible for the court to make a positive finding.
Yeah.
Next question, what is the legal effect of being in that position? Answer, neither can establish that they are the parent, and in the binary system, it must follow as a matter of logical reason that they are not the legal father.
No,
And that
no.
therefore opens the door to section 55A.
I think you can't make a finding that they're not the legal father. Or is that's a very strict application of the
It's-
standard of burden, the
it's
burden of
too
standard of
str- and,
proof.
and I would
Something is
submit
not proved.
it's the type of confusion of analysis which Lord Justice Peter Jackson sought to unpick in paragraphs 39 and 41 of the judgment I referred my lords and my lady to before the break. Because that analysis effectively recognises the common law starting point, and he uses the term baseline position. So if the common law starting point is that there's the simple analysis is that neither can prove that they are the father, you take that state of affairs, that finding, and you ask the question as to whether it follows logically that neither have established that they are the father, and the logical consequence of that is that the declaration of non-parentage must follow. Because you either are or you aren't. And if you are not, then if you are not, then you're not.
Understand that we now know there's a DNA test that could determine.
Well, that's a timing point. That I think one of the things that we haven't relayed to the court is the quite significant amount of doubt as to whether or not these tests, which are it's called a shotgun analysis, which is the very margins of the science, is anybody's confident that it will actually produce a helpful result, because it requires quite a number of significant conditions to be in place. And we've already had information back from King's College London, who are the organisation who will be undertaking that, who are, I think it's fair to say, I think others may disagree with it, are hedging significantly as to what guarantees they can give as to the efficacy of the test that they would undertake. Because it's a very unusual.
I made it not actually to pull you into the submissions about that, but really my concern that you jump from neither can prove it to when you're talking about identity and the importance of truth, which
Yes.
you told us a lot about.
Yes.
You go from not able to prove it to a binary decision, therefore they are not the parent, and the child's life then proceeds on that basis, even when there is potentially scientific options that would.
The child proceeds on that basis, but with the explanatory text which explains why that is the conclusion.
It'd be quite tricky if you're 12.
Understand that, fully understood. But and we really come back to the pure legal analysis in relation to, I think, the point made by my lovely friend Miss McKenna and her colleagues in the skeleton argument as to back to re-B and the binary system, which is what we apply. And how does that operate in this context?
I'll try just once more. It's a general principle of law that if someone raises an issue, the burden is on them to prove it.
Yes.
And I'm sure that applies here as well. Are we still getting ourselves into difficulty because we're looking at both of them together? So if you hive off F1, the proposition for which he contends is that he is the father. If he doesn't prove it, he's not the father.
Yes.
So if you treat it like that and you don't bring in any mention of F2, F1 is not the father.
Yes.
Send that off to the registrar. Now look at F2. The proposition now is that F2 is the father. He wants to be the father. He is advancing the proposition. He cannot prove it. He is therefore not the father.
Yes.
Now, in one sense, obviously, we're looking at exactly the same thing as my previous formulation. But at the moment, I would have thought that that is the necessary outcome. Unless you aggregate them, so put this way: as soon as you aggregate them, you make it too complicated.
I accept that.
So
Individual.
I'm not asking for another 15 minutes, but if you and that I would have thought might satisfy section 55.
That was the point we were making in coming forward effectively with paragraph 4. You might have to space it out a
You
bit.
still have both of them in the same sentence.
I accept that. So then if we disaggregate,
One of those two statements is a fiction.
Yes. So you'd have to have two declarations of non-parentage in relation to both F1 and F2. So this
The only
child
two
would be
people in the
told he
world
has
who
no
might be
father.
the father, and you're declaring that they're not the father.
on the face of the declaration, yes, but on the exceptional facts of
But
this
you're-
case, with
it's a- it's a
explanatory.
It's a contrivance in order to get him the birth certificate changed. So there's a
Or-
need for proportionality.
or to achieve the level of equality as between the two putative fathers.
You can achieve that through the management of your parental responsibility orders.
For
Live
practical,
with and all the rest.
And the truth of the current understanding, which is the child has to be told you can't tell.
except for practical purposes, you can go a long way doing that. But still, the formal documents of identity remain in place, and that's when I track back to all the broader submissions in relation to the documents being accurate and truthful.
Good, that's helpful in,
More of a straight bat than England managed. Anyway,
yes, but you lasted longer than England managed anyway. Miss Markham, did you want to say anything at this stage? We're obviously, we must get to Miss McKenna.
It was the point that we had established in our skeleton argument that we say the learned judge was wrong in the approach he had taken to the binary finding of fact, which is the point my lord made, which is you are seeking to establish a fact on the Reed-Bink standard. You had not established on the balanced probabilities that A was the father, and you have also
That's the
not
strict
established
legal
B.
position.
So it's the strict Reed-B position, which is why I said the learned judge was wrong in the way in which he approached the findings. But I'd only be repeating the same. And I had thought my lord had said earlier that the approach to the registrar would be father 1 had not proved that he was the genetic father, and father 2 had not proved. And whilst it means that for this little girl at this point in time, she doesn't have an identified father, that is her existence. It may feel uncomfortable, and it would be the same for a child if she had 6 fathers that were the possible putative fathers. In this case, it's between 2 brothers, but there may be a situation where one doesn't know between a larger cohort. But that is the truth at the moment on the current evidence.
So, Miss McKenna,
My lord looks to me for the answer.
as ever.
The court, I feel on the mother's behalf, needs to hold in mind that in 2024 was the first judgment of Her Honour Judge Reardon where the finding of equal status, as it were, equal finding was made, and then there were 12 months passed whilst parties looked to see if more acute testing could be achieved. It wasn't, and we're now months further down the line, and my lady is right to seize on any opportunity for testing, but we are on the margins of science at this point. Forget about how much it costs or who's going to pay for it, although very generously I think there's a suggestion if we decide to go down that route, there'll be a commitment from the state, not Ms. Clements, from the Legal Aid Board, for 25%. But the reality is we may end up many months down the line and no further forward, and so something needs to be done now, which is really why the mother supports the appeal, not currently landing where that appeal is heading. Save that, you understand from Mr. Bagchi headlining to you that our analysis is that the declaration requires, I beg your pardon, go back a stage. We know that legal parenthood requires a source of sperm. the progenitor of the conception, at the point of conception, that can't be identified. Therefore, there cannot be any person identified as this child's father. From the pool of two, happily just two, the birth certificate on which society, state, agencies rely for evidence of legal status wrongly records one of the two as father. That is not accurate in law, it's not accurate in fact, and it's misleading to anyone having regard to that. Before we even get to questions of parental responsibility, which can be managed under the Children Act. And so remedy to the birth certificate is required in one way or the other, because at the moment it provides evidence of legal parentage, which doesn't exist as a question of law or as a question of fact for either father. I'm not suggesting that we contort ourselves further and continue to proffer different wording that could satisfy a amenable Registrar General willing to help in this unique set of circumstances. Because I get the impression that this matter is likely to be back before the circuit judge in any event, and regardless of decisions that this court might make at an early stage for matters that don't concern this court today. The findings that Her Honour Judge Reardon has made do not sit well with the manner in which she has sought, and I think she has contorted, to contrive parental responsibility to be retained by one and externally to be exercised by the other, but through the use of prohibitive steps orders and specific issue orders. It's becoming an unwieldy and unmanageable mechanism for the management, the arrangement, better word, for this child. They are likely to be reviewed, but in whatever way they are reviewed, we still have the problem of the birth certificate and the child's identity. So we circle back round, and to urge the Registrar General to be satisfied that the declaration is made in an appropriate form of words, we have to revert to common law, basic fundamental principles, as my lord to your left, Mr. President, has identified. It's a binary issue. He who asserts must prove. If he cannot prove, the fact is not found. Father one asserts. The court can't find what Father one asserts. So therefore, it is not proved. And so isn't the declaration that's required. The court cannot find, so I beg your pardon, the court has not found that Father one is the father to the child. And therefore, addressing the question of is or was, he's neither. He's not found to be the father. And the solution, it's bravely sticking my neck out, where many have tried, but the solution might be that this court, that Her Honour Judge Reardon is asked to make that finding more clearly, and she can safely do that. It would be an indisputable finding, I submit, and that be translated into a declaration.
So the the declaration would be, is it just what you said, that the court has not found F1 to be the father.
Yes,
That's very similar to the declaration that Miss Clements
I'm seeking
took
carefully
instructions
to
on.
reinvent,
That's
and
the,
I know
trouble.
that the wording
the
started the
where
short
my
and the
lord got to, I think,
Might have been
since
closer.
we came back, was that separately, the court would find that F1 had not been proved to be the father, or was not the father.
Well, the binary test is that if a fact is sought to be proved is not proved, then it is found not to be proved. It's the opposite.
exist.
So, my lord,
It sounds as if pragmatically, never mind the pure legalities of it, the registrar won't shift unless they have something which goes on to say, and therefore F1 is not the father.
Yeah.
But on what we were told after the short break, something which says that should be sufficient. The declaration that he's not the father.
yes. My lord, may I turn my back to
Yes,
Miss
certainly.
Wiseman, who's-
Yes.
Miss Wiseman reminds me that we go back to the point about the declaration is not it's the truth of the declaration, not the underlying facts, that is important. They were not seeking to mislead the reader of any declaration, but as a matter of law, Father 1 and Father 2 are not the legal father of the child. And if that is a declaration that doesn't offend, that might be a declaration that doesn't offend the enduring potential that it's one of them. So, my lord, I think I've taken the submissions as far as I can.
Thank you, have. Very, very grateful to you. Thank you, Miss McKenna. Yes, Miss Paisley.
Well, as my lords and my lady know, with my learned juniors, Miss Cabweru Namalemu and Miss Ellsworth, I appear on behalf of F1. We would like to limit our submissions to question 6, which is the most pertinent in our case, namely, what approach should the court take where 2 men are equally likely to be the genetic father of the child? And we would like to make the following propositions. First, that the court should make a finding accordingly, which is what happened in our case. Second, the court in these circumstances we submit is bound to conclude that a declaration of parentage or non-parentage under the statutory scheme in section 55A is not available, since neither man can establish on the balance probabilities that he is or that the other is not the father, and therefore, third, if one man has been registered as the father on the child's birth certificate, since section 14A of the BDRA is not triggered, the section 55A route is not available, there is no mechanism whereby his name can be moved from the register. Unless and until science moves on and things change. And fourth, as between the 2 men, issues to do with the rights and responsibilities of a parent or a quasi-parent or a putative parent can be dealt with, as the judge did in our case, by way of specific issue orders and prohibited steps orders, whereby each of F1 and F2 as equal parental responsibility created by that statutory framework. And we submit it's now clear that section 29 isn't available either.
So the route to equal parental responsibility
Is the orders that were made under section 8 of the Children Act 1989, which were orders, prohibited steps orders limiting the mother's exercise of her parental responsibility without consulting the fathers or an order of the court, namely a permanent removal from the jurisdiction, change of school, change of address, that sort of thing, appear in the judge's order. And specific issue orders permitting, in principle, each of F1 and F2 to take the child on holiday abroad and to take various other steps, and the right to be consulted and so on. So she didn't deal with it on the basis that F1 had parental responsibility. She said she didn't know because of the two conflicting High Court authorities whether appearance on the birth certificate gave him parental responsibility. She dealt with it in a different way. And we say she was right. And we would submit with respect that the judge was not in a position, even if she was asked to grant parental responsibility to F2 under section 12 of the Children Act. He was neither the father nor not the father.
Could she do it, I think, as I suggested, she'd run both options?
Well,
Say if he is the father, I do it under this provision. If he's not, done under the other.
if the court favours a strict interpretation of the words in the statute, we say he couldn't qualify as a father and he couldn't qualify as not being a parent.
But I see what you've done. But where Parliament has said in one provision, fathers can get parental responsibility automatically, I think.
Yes.
That's the difference. And non-fathers can be given it.
Yes.
And the judge considers at the very least he should be given it. And if he is the father, he gets it automatically. Surely Parliament intended that the judge ought to be able to rely on the provision as a whole.
Our submission is, rightly or wrongly, that if you take a strict interpretation, you can't call him a father and you can't call him a
I think that
but we accept it's arguable.
what one wants to do, here we are, we've got a living child and we want the people involved in the child's life to have whatever responsibility or not to have it as is right for the child.
Yes.
A purposive interpretation is going to lead to the judge to do what's right, rather than say, oh, well, I'm stuck because I'm not on the legal
Well, on that basis,
niceties.
she could have granted them both parental responsibility, but she chose to do it by another route.
Yeah.
The section 8 route.
So your basic position is that the judge wasn't in error. She
No.
could have done it differently,
Yes.
but she wasn't wrong in doing what she did do.
And she knew that F1 had parental responsibility for the younger child. She didn't grant him parental responsibility for child A. So we have a situation where a pool finding was made. I don't think anyone suggests that that was wrong. And that finding isn't being challenged by anyone, although there appeared to be a challenge in the course of this afternoon. In fact, that finding has not been challenged. But we say that where F2 asserts that that means the impact of the finding is that neither F1 nor F2 can be treated as a father or non-father, that must be wrong. And in terms of whether there can be any declaration, I think the position is now clear on the basis that the court is likely to accept these submissions on behalf of the Registrar General. But another pertinent point is that in P&Q and F, which has been relied on in support of the making of declarations and in support of the binary point, first, that was a case where Lord Justice Peter Jackson said it's the finding that it was equally likely that the child was conceived through natural insemination via sexual intercourse, and equally likely that the child was conceived via artificial insemination, was a perfectly proper finding. And it meant that the partner of the birth mother could not satisfy the HFEA gateway to displace the genetic father. And he also said, and this we say is important in paragraph 39 of the judgment.
Right, so we need to go to that.
Yes, and that is at page 1453 electronically. And the words that we particularly rely on are where he says that under section 55A in that statutory scheme, the court is not directed to the truth of the underlying facts, but to the truth of the declaration, the legal proposition to be declared.
Sorry, which paragraph are you?
39.
Oh, done, yeah.
And we say that since F2 and the mother were unable to prove that F2 was the child's biological and therefore legal father and that F1 was not, there wasn't a declaration that could be made. And we say that fits entirely with P and Q and F rather than being, and so P and Q and F does not assist.
To read that.
The other point, which is significant, is that if an amendment were made to the register, so if there was a re-registration.
Sorry, I'm hung up on in P and Q. It wasn't. He was a depending on the circumstances, the conception. He was a donor, and the court is referring in the judgments to the Human Fertilisation Embryology Act.
Yes.
And I think Mr. Bagji said, of course, if it had been conception when he was the donor, he couldn't be the father. I don't think that applies. That only applies if it's through an IVF, registered IVF clinic that comes under the Act. If it's just a friend of the couple who act as donor, then if he's the genetic father of the child, then he's the father.
Yes.
So it may be that I misunderstood either what I've read.
That the genetic father had had sexual intercourse
Yes.
with the birth mother, but also his.
Yes. But either way, he
Yeah.
would have been the legal father.
Yes.
Yes, good. I'd misunderstood.
Yes,
Yeah.
Because it was informal.
Yes.
No.
Yeah.
No,
Wasn't it? No,
they were using a licensed clinic as well.
Ah.
Yes,
It was a licensed
it
clinic.
was.
Well, he couldn't get through.
So how did they? So can you go with a known donor to the licensed clinic? I thought the licensed clinic, the
No,
donor
the
was
HFEA
anonymous.
requires that the conception was as a result of artificial insemination, and therefore the second parent, the mother who wanted to be the second legal
Well,
parent.
I
had to be
think
registered.
we're not going to get. I'm going to read the case. So I've got another case which some of you are in, where it's a sperm donor case, and I'm being told that although this was a donation, there was no ambiguity as to whether sexual intercourse taken place. He's the legal father, but it didn't involve a clinic at all.
Well, I think if it's informal,
Rather more homely arrangement.
the position is different.
Yes. So I need to read the judgment. Yeah.
Lord, I've been told, Mr. Eaton was in that case, he sits behind me, and he indicates the pivotal distinction was that the birth mother and the partner were married, and that triggered a different analysis.
Right.
It didn't require the use of a licensed clinic.
It did.
Did not.
Didn't.
And no, under section 42, you don't have to be, if you're married, you don't have to use a licensed clinic.
Right. I'm even more confused now. Right, well, we'll read the judgment, there's no need to be confused. Sorry, Miss Paisley.
Not at all. Another assertion certainly made in writing by F2 is that both F1 and F2 are genetic fathers, and we find that at in the court bundle 313H, paragraphs 25 to 26. And our submission is that
So 331,
313H, which electronically, I'm turning my back because I'm afraid I'm on the paper. 321, thank you. 321 electronically, paragraphs
you.
25 to 26.
Okay.
We submit that the results of standard DNA testing were that each man had a 99.9% chance
Yeah.
of being A's father.
Yes,
Which is not the same thing.
if without disclosing the identical
Yeah.
twin element, if either man went for DNA testing, they would say, you are the father.
Yes. The next point is that the court was right in respect of declarations. We dealt with that.
We actually see the declarations, which are slightly different from the way she puts it in her judgment in the order, don't we?
Yes.
Right,
Yes.
so
Actually, rather more towards how Justice
Yes.
Stuart-Smith described them.
Pages.
It's in the bundle, which is the welfare bundle
Welfare.
P, part 1,
Cool.
page C3. So I just pass it.
Yes, all right, yeah.
If you have it, if you have the core bundle more conveniently, my lord, it's at 219.
Thank you. Notices. Confidential recitals.
Hard copies.
Number 3.
Actually at 220. Which is
It's declared the jurisdiction
221 electronically, I'm told.
declaration application is refused. So sorry, which declarations is it said that? So it is the recitals. It's upon the court rejecting the case advanced by the guardian. I mean, that's the case that was rejected. Sorry, which paragraph
Yeah, that's
are
not it.
you referring to?
It's just that the course had rejected them in that.
Right, yeah, thank you. Oops. Good.
So
Yeah.
as to F2's argument that the judge's finding that the burden of proof was no assistance offends the binary rule, we rely on P and Q and F. And the mother appears to agree with that proposition. See Core Bundle 288, paragraph 45. But extrapolates that by going on to suggest that neither F1 or F2 could be the common law starting point. Therefore, a non-parentage declaration in F1's case was appropriate, and we say, as is now we say abundantly clear, that's not correct either. And we don't understand on which basis that could be said to be right. And the judge dealt with the declarations sought at the hearing before her by F2 at paragraphs 103 and 104 of her judgment, and we find that in the court bundle at 238. Which matches, yes, right at the bottom of 238.
Which paragraph?
103 over to 104.
Turnover.
Ms Whelan was saying in those circumstances, the arbitrary selection, as it would be of one father, would represent a less significant interference with A's Article 8 rights in the situation which is father's ingenious but unsustainable, and we respectfully agree.
Both observations.
Yes. I'm sorry, I'm being a bit slow. I'm trying not to
No, don't
deal
worry.
with things that have been resolved in our submission this afternoon.
Very good to be
and move on.
editing as you go on.
Yes. We submit that the inherent jurisdiction doesn't assist. Both F2 and the Guardian seek to utilise it, albeit in different ways. F2 deals with it in the original skeleton argument, which is only in the welfare bundle at A31, paragraph 74. Electronic. Give you the electronic reference in a moment, if I may. Paper reference A31, paragraph 74, and it's A34. 34 electronically. And we see what is stated: in the event the court does not feel able to utilise the section 55A statutory scheme, there is nothing preventing the court from invoking the inherent jurisdiction to determine parentage on a social psychological basis. So that's the F2 position. The Guardian at the time was seeking the declarations that the court has heard about at some length, 1 to 3. We submit that the inherent jurisdiction cannot and shouldn't be used in an attempt to get round section 55A of the Family Law Act. And one of the authorities we rely on in respect to that is REG, recognition of Brazilian adoption.
Sorry, read G.
REG, brackets, recognition of Brazilian adoption, 2015, 1 FLR, 1402, which is in the authorities bundle at 2007, where in a case under section 57 of the Family Law Act, the court was clear that it should not use the inherent jurisdiction where a statutory regime was available. And we note that the Registrar General agrees with that proposition, and we find that in the skeleton in the core bundle at page 371. Our further submission, and we say this is an important submission in terms of child A, those who seek the declaration seem to ignore the impact of making declarations at this stage. As in the Secretary of State for Work and Pensions and James, once a declaration of parentage or non-parentage is made, this is binding and cannot be challenged. That case is found in the authorities bundle at page 2493, and we rely in particular on paragraphs 17 and 18, which are on page 2498. And at 17, there's a reference to section 58(2) of the Family Law Act, says that the effect of a declaration of parentage applied for under section 55A is, by reason of section 58(2), binding on everyone, including Her Majesty. And then 18, if the wrong done to K by the Bridgend Family Proceedings Court is not put right by this court, it can never be put right in the future. And in our skeleton argument, we reference a number of other authorities, including the Amptil Peerage. Amptil Peerage is at page 568 of the authorities bundle, G to H.
But this is, I'm not sure the relevance of this part, because no one's inviting us to make a positive declaration that F1 or F2 is the father.
Yes.
So your submission that if we did, that would be for all time, and it's a big thing, we shouldn't do it, is obviously well made. But no one's asking us to do that. They're inviting us to consider declarations in the form that we've all got used to during the course of the afternoon, which is not that.
You were being invited to take F1 off the birth certificate.
That's a different thing.
Well,
These are
if-
authorities. The birth certificate can be is not for all time. It can be amended.
If there was a re-registration,
Yeah.
that couldn't be amended. So if F1 was
I think
taken
you can,
off,
presumably you can re-amend the re-amendment.
our understanding is that that's not correct, and we stand to be corrected, but that's our understanding, that once you have a re-registration, it's there for all time.
Right.
My lord, I think
It must-
it's tied to section 55A. The thing that triggers the re-registration is 55A.
Yes.
If the 55A declaration is there for all time, it would seem to follow that
Yes.
what's said is correct. But
Yeah.
I say that without any instructions and simply.
But where we're contemplating a declaration which falls short of the positive he is the father or he is not the father, then going round in circles, the Registrar General said that's not enough to trigger re-registration, so we don't get there. I think that's
My lord's already made the point that the parties and the child have the truth in the judgment. And what needs to happen now is some kind of narrative needs to be developed, and the judge had that very much in mind. So any declaration short of a declaration that fits within the statutory framework in section 55A is not going to be helpful.
no.
And I don't know if I need to say anything about the possibility that we could have a definite answer currently.
But it sounds as if that's not the
It's not straightforward.
magic wand that would have
It's not
we all thought
straightforward.
it might be. Yeah.
We recognise that science is moving on all the time, and that these more sophisticated tests
Yes.
may develop and so on. And so the time at which a declaration might be made is a time at which there is, it is possible to
Yes.
make a declaration which is truthful and which gives the child an answer. and that's always going to be possible. I'm just looking through to see whether there is any other point taken against us which I ought to deal with. So now just have a moment.
Yes, please do.
And turn my back. No, my lords, my lady, I
Very
think
quick,
that
very
covers
quick
our
answer. Yes.
submissions. Thank you.
Good. Thank you, Miss Paisley. Nothing else. So where have we got to now? I'm looking at a number of things. One's the clock, and the other is the running order, where we've gone slightly out of order anyway. So we've clearly got the two interveners, Ms. Cavan and Mr. Gratian, to hear from. Are you, Ms. Markham, you get a right of reply, and Mr. Bagchi does, on what's been raised this afternoon. Are you also then going to make further submissions about welfare?
Depends if you require us to or not. I had thought the indication earlier was that perhaps that wasn't going to be required if the appeal was allowed in relation to the parental responsibility.
Well, I think that we're certainly attracted by the idea of the matter going back to the a judge, you'd say,
Yes.
not the judge, to look at ways, and I need to be reminded, well, Paisley submitted that the judge did make orders under Section 8 and did grant parental responsibility.
No. She, the learned judge made specific issue orders and curtailed
So to
use
contempt the
of
mother's PR.
the mother's PR,
Right,
but
that's right.
no parental responsibility made in relation to my client, hence the appeal,
Yes.
in relation to that aspect.
I think for my part, I'm attracted that, and Miss McKenna
Yes.
indicated there may be issues that we don't know about that might
There
take the case back to the judge.
There are, and we're treating
Anyway.
carefully in relation to that.
So on that basis, I don't think we need to hear from you on the welfare issues.
And in relation to any right of reply, I think I have been standing up as we go along. All I would invite my lord, my lady, to remind yourselves is in particular our ground 1 and 3 of our appeal. And ground 1 was particularly directed to the application of Re B, and where we say the judge went wrong seems to have been lost, and it looked like that was a point that developed. It was our first ground. So whilst we weren't necessarily seeking a fine against the fact, we were saying the way in which the judge legally addressed the facts was wrong because she didn't follow Re B. And ground 3 was that the learned judge didn't consider a declaration of non-parentage. So that ties into everything been saying, but those two grounds were very plainly there.
Are there any other parties in either of the other two cases who are thinking that have got further submissions to make?
I shall sit down.
Mr. Momtaz.
Just dealing firstly with the question my Lord raised, I think before lunch, in terms of whether we require a welfare hearing in re if my Lords and my Lady find that the learned judge's primary conclusion in our case was correct, i.e. that the appellant never had parental responsibility to begin with, then her alternative conclusion does not rise or engage. So on that basis, we would not be pursuing the welfare into that hearing.
But that's very helpful.
No time is necessary for that tomorrow afternoon. I have specific instructions on that from my client. I asked him about it, he was at the court earlier.
Okay.
So we don't require that time tomorrow afternoon, which the court set aside. We may want to make some very short submissions in reply.
Well, I think the sensible thing now is for us all, I'm a bit bewildered after all these 3 cases, and it's now 4:10. So I think it would be sensible, unless that's going to inconvenience those who are appearing pro bono for interveners. Is that
I'll make accommodations, there's no difficulty. I was going to stay in London in any event.
right? Well, I'm very conscious that both presumably reunite are in the same position. Is it going to inconvenience you to come back? You always plan to come back tomorrow anyway.
Well, yes, we can again make accommodations.
Well, I think, unless my lady or my lord take a different view, that we'll take stock, all of us overnight, and not encouraging all 35 of you to make further submissions, but if we're keen to get this clear, and if there's other matters you want to raise, then you'll find us willing to hear from you. So if we say 10:30 in the morning, is that convenient? Good. Well, this is an unusual case, and and I'm grateful to you all for what you've delivered so far. I've been looking, have we got Judge Reardon's fact-finding judgment in the bundle? I'm looking in the welfare bundle, it wasn't there.
I'm not sure you have, my lord, but my lady, we will
I
send
think,
that to you.
not, because I just, in terms of our judgment, it would be helpful to understand the basic the findings of fact that she made.
It is published, it's on Bailey, but I will ensure
Could
that you
you
have a
let-
copy of it sent to you.
Please, thank you. 10:30, thank you.